afternoon, everyone. Thank you for joining us today. Our online talk will be starting shortly at 3 p.m. For those who are here early, thank you for waiting patiently. While you are waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Hello, everyone. Thank you for joining us today. The title of our online talk today is whether the non-renewal or fixed-term employment contract amount to an unfair dismissal. My name is Diana. I'm a senior associate with Ma Wing Kwai & Associates, and I will be your moderator for today's session. Before we start today's session, allow me to introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment department, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 movement control order, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Today's talk is the 24th talk in our MWK online talk series. Visit our website at mawingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice for your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now allow me to introduce our speaker for today, Mr. John Chan is a senior associate in our dispute resolution, employment, and strata departments. He holds a Bachelor of Laws from University Kebangsaan Malaysia and was admitted to the High Court of Malaya in 2014. John hopes to complete today's talk by 3:45 p.m. and thereafter proceed with the Q&A session. So if you have any questions, please don't forget to post them up on Slido and our speaker will address them later. You should have received a link to Slido during registration, but I will leave this slide up a while so that you can scan the QR code before we move on. Alternatively, you can go to Slido's webpage and key in the code 49992. I repeat, 49992. It is common for businesses to hire employees on a fixed-term contract on the assumption that the renewal of the fixed-term contract is at the option of the employer. However, this may not be the case, as the court may decide that a fixed-term contract is in substance a permanent employment contract, the non-renewal of which may amount to unfair dismissal. In this talk, our speaker will discuss the legal principles on fixed-term contracts. With that said, I will now invite John to share his insights. Over to you, John.
Thank you, Diana, for the introduction. Yes, so before I go into the topic of fixed-term employment contracts today, I would like to quickly touch on the procedure under Section 20 of the Industrial Relations Act 1967 on unfair dismissal claims. Now, Section 20 allows an employee who considers that he or she has just been dismissed without just cause and excuse to file this representation to the Industrial Relations Department to be reinstated. The basis for Section 20 is to encompass the principle of security of tenure, where we can see in Hong Leong Equipment, the court equated the security of tenure to the security of property. And it says that you can only dismiss an employee with just cause and excuse. The representation must be filed by the employee within 60 days from his dismissal. And this is the process that will take place once a representation is filed by the employee. The department will call both parties, the employee and the company, for a negotiation settlement, or what we call reconciliation session. If an amicable settlement is achieved, the matter will end there. But if no settlement is achieved, the department will then notify the minister, and if the minister thinks fit, he will refer the representation to the industrial court. And this is the procedure or the proceedings that will happen in the industrial court. Generally, the court's KPI to dispose any case is 6 to 9 months. You can see here the documents that need to be filed by each party, followed by trial, written submissions, and then the award will be given by the court within 3 months after the filing of written submissions. For the award, the industrial court may grant reinstatement because that is under Section 20 of the Act. If reinstatement is not suitable, then the court will grant compensation in lieu, which is usually calculated 1 month's salary for every 1 year of service. And also the court may grant in its award back wages, which is a maximum of 12 months for the probationer and a maximum of 24 months for a permanent employee. And the burden of proof to prove that the employee's dismissal was with just cause or excuse lies on the company in the industrial court. Now we go to the question of what is a fixed-term employment contract. The starting point would be Section 11 of the Employment Act, where subsection 1 says that a contract of service for a specified period of time or for the performance of a specified piece of work shall, unless otherwise terminated in accordance with this part, terminate when the period of time for which such contract was made has expired, or when the piece of work specified has been completed. And subsection 2 talks about a permanent contract. So essentially, an employment contract, a fixed-term employment contract is an employment contract for a specific period of time only, or for the completion of a specific project only. So I've put 2 examples here. the first example is a term for a specific period of time. Your employment as a sales executive will be for a period of 2 years, starting from 1st January 2020 until 31st December 2021. So that's 2 years and it's fixed. The second example is your employment as a consultant for ABC Sdn Bhd shall commence from 1st January 2020 until the completion of the LRT5 project. The completion date shall be the first day of ordinary public service of the LRT5. So here is an example of the completion of a specific project. So the date of when the LRT5 starts its public service, that's the day where the fixed term employment contract ends in this example. Now we take a look at what the cases have defined fixed term employment contracts. In the case of Hanqiang School, the court defined fixed term contract where both parties recognize that there is no understanding that the contract will be renewed on expiry. Such fixed term contracts or temporary one-off jobs are an important part of the range of employment relationships. These contracts can be found in seasonal work to fill gaps caused by temporary absence of permanent staff, training, and the performance of specific tasks such as research projects funded from outside the employer's undertaking. So this is examples and a definition given by the courts in this case. Now, we look at the general principle in the context of Section 20, which is unfair dismissal. So the general principle is that there is no dismissal when a fixed term contract ends. In another sense, the employer's non-renewal of fixed term contracts do not give rise to an unfair dismissal. In this case, you can see that the court has defined a fixed term contract as one which has a definite beginning and a definite end. In common law, a contract for a fixed term expires. It terminates of itself. It has not been terminated by either party. In the conventional sense, there is neither dismissal or resignation. In the case of M. Vasagam, once it is established that there is a genuine fixed term contract, the dissolution of the contract upon the expiry would clearly spell the end of the employee's tenure with the employer. And in Colgate-Palmolive, the Court of Appeal held that an employee in a genuine fixed term employment contract leaves at the expiration of the fixed term, and that is just cause enough for the employer to formally bring an end to their employment relationship. So that is the general principle on how the courts will treat fixed term employment contracts in Section 20 unfair dismissal claims. If you realize in the quotes that I have read out here in M. Vasagam and in Colgate-Palmolive, there's the word here which is genuine fixed term employment contract. Similarly here, the courts use the word genuine fixed term contract. So we can see that the determination the courts will use is whether the contract is a genuine fixed term contract or it is actually a permanent contract in disguise of a fixed term contract. And this determination was set out in the Hanqiang School case, where the court said that fixed term contracts are not excluded from the provisions on security of employment in our act being the Industrial Relations Act. And the primary question that the court will ask and determine is whether the employment contract in dispute is in fact a genuine fixed term contract or a permanent one disguised as a fixed term. In the case of Ahmad Zahri against Ames Cyberjaya, the federal court held that the question of whether an employment contract is a genuine fixed term contract may be divided into three considerations. They are the intention of parties, the employer's subsequent conduct, the nature of the employer's business, and the nature of work which the employer was engaged to perform. So these are the three considerations. Now we look at the first consideration, which is the intention of parties, and we will be using case law as examples. We go back to the Hanqiang High School case. So in this case, the employer was the school who employed teachers on fixed-term contracts of 2 years. Some of these teachers had taught at the school for more than 20 years, and their fixed-term contracts were renewed repeatedly during that period of 20 years. Thereafter, there were some teachers who joined the Union of Teachers in Independent Schools. The school informed those teachers that their employment would cease upon the expiry of their fixed-term contracts. And the school really did not renew these contracts at the end. And so the case went to the industrial court. And during trial, the chairman of the board of governors came as a witness, and he admitted that the so-called fixed-term contracts had become nothing more than a chess piece in the school's attempt to prevent the formation of the union by the teachers. The court also saw that in the fixed-term contracts, there was a retiring age term, which shouldn't be there in a fixed-term contract. So at the end, the industrial court held, although there might have been a genuine need for fixed-term contracts for the teachers when the school was first inaugurated, the court cannot see such a need when the school had become established successfully. Some of the teachers have taught there for more than 20 years and have had their contracts renewed unfailingly during those years. Indeed, the practice had long been to give automatic renewal by the end of November or early December. The system of fixed-term contracts in the school was employed not out of genuine necessity, but as a means of control and subjugation of its teaching employees. The employments of the 35 claimants, the teachers, are ordinary employments dressed up in the form of fixed-term contracts. These are not genuine fixed-term contracts. And then the court went on to hold that their employment fixed-term contracts were not genuine and were in fact permanent contracts. On to the second consideration, which is the employer's subsequent conduct. The court will look at the employment's conduct during the course of the employee's employment and also the employee's duration of service with the employer. In the case of signed UEP development, the facts are that the company employed a clerk under a fixed-term contract of 1 year. Subsequently, the fixed-term contract was renewed each year for a total of three more years. And at each expiration of the fixed-term contract, the company renewed his contract automatically without requiring the employee to apply for such renewals. At each renewal, the company also gave him salary increments. And during his total 4 years of employment, the clerk was involved in various projects. And for his fifth term, the company decided not to renew his so-called fixed-term contract on the basis that there was a slowdown in the business, and the last project in which the clerk was involved in had already been completed. So based on this non-renewal, the employee took it to the industrial court, and this is what the court held. It will appear that having worked for 4 years with the company and possessing a clean record of service, the claimant is not guaranteed security of tenure. Should the company be empowered to throw him out merely on the grounds that his contract has expired and that the company is in no position to offer him a new contract? The court opines that this is highly undesirable state of affairs, unconscionable and repugnant to the principle of security of tenure and an injustice that social justice seek to correct under Section 20 of the Act. In the circumstances, the court was of the view that it was an implied term in the clerk's employment with the company, that he was in fact and in law a permanent employee, and that the contract between the company and the employee was a permanent one dressed up in the form of fixed-term contracts. So here the court also considered all the evidence and the facts and the employer's conduct and decided that the so-called fixed-term contracts were all actually one permanent employment of the clerk. On to the third consideration, which is the nature of the employer's business and the nature of the employee's work. And we look at the case of Malaysia Airlines Berhad against Michael Ng. In 1988, the company employed the claimant as a pilot for 2 years, which would last until 1990. He was then given an extension of 3 more years until 1993, and a further extension of 3 more years until 1996. At the end of the 1996 fixed-term contract, no renewal was given to the pilot. In the case, the company alleged that the claimant was employed by the company to work in the rural air service, that the service operated by the company was itself temporary in nature, and for this reason, the company did not offer permanent employment to the pilots. And the company also alleged that the claimant was aware of the temporary nature of this service and of his work. However, the court said that in examining employment contracts to determine true character, the court must take into consideration, amongst others, the nature of the employer's business and the nature of the work which an employee is engaged to perform. Of particular importance is a consideration of the temporal circumstances and the actual outworking of the contract. Taking the above factors into consideration, the court observed that the service for which the claimant had been engaged can hardly be said to be one-off in nature. Is it temporary in nature? The court does not see that the rural air service is temporary. The circumstances of the claimant's tenure with the company shows that he was employed in an integral part of the company's ongoing business operations, rather than to a service or operations which must of necessity be for a fixed duration. So in essence, the court in this case looked at the factors, the nature of the rural air service and the nature of the pilot's work, and decided that no, his fixed term contract is in fact permanent because the rural air service is not temporary, and the employee's work is also not temporary. So from these three considerations, some parts overlap, which is the intention of parties to the contract, the subsequent conduct of the employer, and also the nature of employer's business and the nature of the employer's work. The elements do overlap, but the court will consider all these considerations in deciding whether a so-called fixed-term contract is genuine or not. Before I move on to this extra topic of whether a foreign employee can be employed on a permanent basis, I just want to say that why the argument of whether a fixed-term contract is genuine or not is because an employee who is in a fixed-term contract, if his contract is not renewed, he may bring this Section 20 unfair dismissal claim on the company. Or if an employee is on a fixed-term contract and before the end of that fixed-term contract, the company terminates him for whatever reason, he can also bring unfair dismissal claim on the company. And usually the employees may or may not decide to bring up the issue that his fixed-term employment was actually on a permanent basis, so the court will have to decide on it. Now, can foreign employees be employed on a permanent basis? The federal court decision in Ahmad Zahri against Cyberjaya. Previously, the courts took the position that a foreign employee cannot argue that he or she is a permanent employee because he or she would require a valid work permit visa to work in Malaysia. And this all started in the case of Nashaat Muhi Mahmud in I think around 2012, 2013, when the industrial court held that the normal practice where companies employ foreigners to work for them as a stopgap measure, as it requires a valid work pass, which is only for a limited period and can be cancelled. This is the reason the claimant's contracts were subject to him obtaining a work pass. In the circumstances, it is not reasonable for the claimant as a foreign workman to say that he expected to work in Malaysia on a permanent basis just because his fixed-term contract was renewed. In 2015, in the case of Toko Inomoto, similarly, the industrial court held that the claimants were employed on a fixed-term basis because they are foreigners, and their employment in Malaysia is therefore subject to them obtaining the necessary work permit or employment pass from the immigration department. In the circumstances, the company is not in a position to guarantee automatic renewals of fixed-term contracts to any of its expatriate musicians, including the claimants. So these two were industrial court decisions, deciding in similar sense. And then came Cyberjaya against Ahmad Zahri in the Court of Appeal, where as at before 28 November 2019, this was the legal position, where it cannot be said that an expatriate who requires a work permit to work in Malaysia can be a permanent employee. Thereafter, in the case of Peter James and against Yayasan UEM, the industrial court was bound by the Court of Appeal decision in Cyberjaya, and therefore decided that the claimant, being a foreign employee, could not reasonably expect himself to be in permanent employment in Malaysia for an infinite period of time, when he knew fully well that his employment was subject to him obtaining a residential visa and work permit employment pass periodically. Therefore, his contracts clearly did not provide for such a situation of permanent employment. Now, the parties in the earlier case of Cyberjaya appealed to the federal court, and on the 28th of November 2019, the federal court reversed the Court of Appeal decision and decided that the citizenship of the appellant claimant, who was a foreign employee, has no bearing in deciding whether the appellant claimant was in permanent employment or in employment under a fixed term contract. In our judgment, the decision of the Court of Appeal that a foreign national cannot have a permanent contract of employment cannot withstand judicial scrutiny and is liable to be set aside. In the circumstances of the present appeal, the fact that the employee is a foreigner is irrelevant in determining whether the dismissal is with just cause or otherwise. And the Federal Court decided on this basis. Firstly, the Industrial Relations Act does not discriminate between citizens of Malaysia and non-citizens. Section 2 defines workmen as any person. Secondly, Malaysia is a member country of the International Labour Organization, ILO, and Article 10 of the ILO Migrant Workers Convention states that each member for which the convention is in force undertakes to declare and pursue a national policy designed to promote and to guarantee equality of opportunity and treatment in respect of employment and occupation for persons who as migrant workers or as members of families are lawfully within its territory. So that's the second point. And the third point was that all workers should be treated with fairness, dignity, and equality without distinction whether they are local or foreigners. Article 8(1) of our Federal Constitution provides that all persons are equal before the law and entitled to equal protection of the law. So what are our key takeaways today? Firstly, the courts, as a general principle, recognize that genuine fixed-term employment contracts do exist. However, express words like fixed-term, temporary, and one-off in the employment contracts do not mean that the courts will interpret those contracts as a fixed-term contract automatically. So employers should assess whether there is genuine need for a fixed-term contracts with their employees or new employees. Employers should review and vet your template employment contracts for permanent ones and for fixed-term ones. Always consider the nature of your business and the employee's role when offering them whether fixed-term or permanent contracts. Always be mindful of your conduct as employers when dealing with employees throughout their tenure. If you decide or are deciding not to renew a fixed-term contract, do consider the real reason. Is it because of his performance, or do you just not like him, or is there a redundancy situation in your company? Foreigners can be employed under permanent contracts, so don't assume that because you're employing expatriate, that if there's any dispute, he can never raise the issue that he is under permanent contract, because now he can. And finally, always seek legal assistance for all these key takeaways that I've mentioned. That is all for what I have to present today. Back to you, Diana.
Thank you, John, for sharing with us. We will now take questions that some of you have posted on Slido. You can ask us questions on Slido either by scanning this QR code or going to Slido's webpage and key in the code 49992. I repeat, 49992. We have quite a few questions today. As such, we'll be limiting our Q&A session to questions that concern fixed-term contracts. The first question, does it mean if the fixed-term contract is renewed year after year, it can be implied as permanent employment, especially with increment in rate? John, can you let us have your thoughts on this question?
Yes, as we saw in the case against, I believe, UEM, where the court saw that found that the employee was given increments for each renewal, and he was renewed year after year automatically. He did not need to apply. The court implied and found that fixed-term contracts were actually on a permanent basis. So yes.
Okay, thank you, John. The next question. In a situation with no revision in rates, how does the employer avoid unfair dismissal for non-renewal? They must have valid reasons for non-renewal to avoid unfair dismissal, or the expiry of the fixed term plays no significant role if the employer still faces unfair dismissal? So 1A, B, and C is a question. Yeah, it's the same question.
No revision in rates. How does the employer avoid unfair dismissal for non-renewal? Yes. So again, you have to consider, why are you not renewing the employee? If you are certain that the contract or the fixed term contract is genuine, then yes, do let the employee know that by the end of this fixed term, the company will not be renewing the contract, and that's it. But if you after considering know that you're actually not renewing the contract because of misconduct or poor performance or redundancy, then you have to address that situation. So that comes to 1B, where valid reasons for non-renewal or the expiry of the fixed term plays no significant role, right? So the employers must realize that however you dismiss an employee or you do not renew a fixed term contract, the employee has the right to file the unfair dismissal claim. Right. So you have to ask yourself, why are you not renewing the fixed term contract? If you feel that it's a genuine fixed term contract and the nature of your business, the nature of the employee's work shows that the employment is a genuine fixed term, then you can go ahead to not renew. But if you think that you are at risk of the court finding that there is a permanent employment, then you should address that situation when you decide not to renew it.
In other words, you must have just cause an excuse if you want to terminate your employee.
Yes.
Yeah. Okay, thank you, John. Okay, we'll take the next question. We have employee who work as a contract staff in the security line. Is there any law or employment act stated which after end the contract period must have a break period between new contract and old contract? If yes, how long is the break?
Right. Thanks, Diana. Firstly, there is no law or employment provisions to state that after the end of the contract, the fixed term contract, there must be a gap between the old and the new one. But we have seen cases on the issue of fixed term contracts where the court found that there was no gap in between each renewal. And because of that, the court decided that it was a permanent contract. So in terms of what is a reasonable period for that break, for that gap, it's really depending on the nature of work, nature of business. And if in this example, it's a security, even with that gap and that break, the court may still decide that security is an integral part of the nature of business. And so even with that break, the court may still find that all those renewal and the fixed term contracts were actually on a permanent basis. So if you want to talk about the period of the break, there is really no answer. It will really determine on the facts of your case. Are you saying that within that break you won't have any security? That's really something for you to consider in terms of the fixed term contract. So if the security is an integral part of your business or a requirement for a business, then why not just give permanent employment?
Thank you, John. Next question. How many renewal does it take to change to permanent contract from fixed contract? And this is quite similar to the question earlier. Yeah.
From the cases that we've seen and the examples that I showed earlier, there is really no answer to this. It can be good because some fixed term contracts last for 3 months, and then every 3 months it's renewed and renewed. So it will determine on a case-by-case basis, really.
Next question. If a staff is employed for a year till 31st of December 2019, extension of contract issued on the 1st of April 2020 until 30th of April 2020, can the staff ask for termination or retrenchment benefit?
Let's see.
I think it is in the context of if, if in the case of retrenchment and if the staff's contract is renewed for a month. I think that is what the question is asking. Can the staff ask for termination or retrenchment benefit?
It ends on end of 2019, and then he was re-employed for 1 month in April.
Yeah.
And
can the staff ask for termination or retrenchment benefit?
I see.
Perhaps the this the participant who posted this question, do you want to clarify a little bit? Termination. Sorry, yes.
I think if the staff was terminated or retrenched during, rather in April, I would say yes. I wouldn't say the staff can ask, because for any situation, the staff cannot definitely ask. But in terms of whether the staff can file the unfair dismissal, I would say yes. Then the court will have to determine whether that extension in April for 1 month is a fixed term or a permanent basis. That's the first decision to be made. And then the court will then look at whether the termination or the retrenchment was just...
whether it was done in good faith or not. Yeah.
So whether the staff can ask for termination benefits, that's really up to the staff and the company to ask and give. But in terms of the disputes, that's how it is. I think there will be 2 layers of issues to be determined in court if it goes to industrial court.
Next question. Do we need to inform employee at the end of contract that we are not going to renew?
Yes, I would say yes. On a goodwill basis, you should maintain communication with your employees. That is a good HR practice. If you should keep track of each employee's contract, and if you should know that it's coming to an end, and you should give notice or inform the employee that you are not going to renew, or rather just to inform that the contract will end on this date, and that's that. Some fixed term contracts will say that letter will be given to you or notice will be given to you 1 month before your last day to inform you that your contract will or will not be renewed.
Okay, next question. If the employer overlook on the contract and realize the contract has already expired for quite long time, what should the employer do?
For this expired for quite a long time, assuming it's 3-4 months after the actual expiry, what the employer should do is to write to the employee, and it's really up to the company. Like I advised just now, consider the nature of business, nature of work, and really determine, does the company want to take the risk of having to deal with the issue of fixed term or not fixed term, or just analyze and accept that, okay, this employee should be on a permanent contract, and in that 4 months later offer that employee either a renewal or a new contract confirming on a permanent basis.
Or maybe a letter to extend. It can be possible as well.
The letter can always backdate. So to say effective on the last day of the last contract to next year, we've decided to renew.
If a company engaged the contract staff yearly renewal through a recruitment company or agent, the staff will have to sue the company or the agent.
In this context, usually the employment contract would be between the company and the employee. So the employee will be, in a sense, bringing the unfair dismissal claim against the company, which is the employer in the contract.
For a non-genuine fixed-term employment contract, to not renew contract for poor performance, does the employer have to put the employee through performance improvement plan?
Right. Okay. In this question or in this issue, there can be 2 elements. So the first element is if the so-called fixed-term contract already states that your renewal will be on a performance basis, which is very common for executives and CEOs nowadays in big companies. They are always usually on 2 years fixed term, and renewal will be on a performance basis, performance improvement basis. So in that first element, it will be easier to not renew, but the company must be able to show that the tracking of the performance was done, and the non-renewal will be on the basis of poor performance. Whereas on the second situation, if there is no performance term in the fixed term contract and the employer decides not to renew because of performance issues, then the same considerations in a performance-based issue in permanent employment will arise, which is you shouldn't decide not to renew without giving warning, without giving chance to improve.
And also here, and also here, the keyword here is a non-genuine fixed-term employment contract. So it may give rise to a possibility that the employee is employed permanently.
Correct.
So if you, so for a permanent employee, if the employer thinks that the employee is not performing or a poor performance, then the employer should first discuss with the employee, troubleshoot problems, then give the employee an achievable or practical KPI to achieve, give time for the employee to improve, and then review at the end of the timeline. Yeah, that should be the correct way.
So to answer this question shortly.
Next, how if the contract employee who had misconduct, like not report to work and discipline issue, can it be a reason to the company not to renew the contract?
Right, so similar to the performance issue, if there's issue of misconduct, you don't even have to wait for the end of this contract, this so-called fixed-term contract. If the contract is for a year, and on the 5th month there is misconduct, the company should deal with it straight away. If it's serious enough, you can give notice or without notice and dismiss the employee straight away. But if the company does not do anything, and at the end of the first year or at the end of the term issues a letter to say we are not renewing because of this misconduct, then it can amount to condemnation, because when the misconduct happened, the company did not do anything. Right. So
yes,
when the employee brings the unfair dismissal claim against the company, there will be twofold again.
yes.
Whether the contract is fixed term or not fixed term, and then whether the dismissal is fair or not, because there's allegation of misconduct. So in short, you don't have to wait for the end of the term. You should deal with it straight away and decide on the punishment straight away if the company finds there is indeed misconduct.
Next question, and I assume it's the last question. If the employee requests to resign before the contract ends, what action can the employer take?
Resign before the contract ends. Right, nowadays, almost all fixed term or permanent employment contracts will have a termination clause, 2 months notice, 3 months notice, or payment in lieu. So if the employee follows that and gives the notice period, it is following the contract itself, and there's really nothing the employer can do.
Thank you, John.
No problem.
And that's the end of our Q&A session today. Thank you for sharing your insights, John.
Welcome.
Before we conclude, I have a few announcements to make. First, please join us again for our upcoming talks. On the 17th of August, which is next Monday, our partner Puan Sarah Kembali and our associate Mr. Marcus Leong will give a talk on Penjana Initiative. Later, on the 19th of August 2020, our partner Ms. Leslie Lim will give a talk on how to make a pact in the arena of sports. And on the 26th of August 2020, our partner Ms. Christine Toh and our associate Ms. Wong Su An will give a talk on understanding performance bond. Secondly, please fill in our feedback form and tell us what you think of our talk. The link to the form will be posted in the chat. We appreciate your comments so that we can continue to improve our MWK online talk series for you in the future. Lastly, if you would like to speak to our lawyers, we offer a complimentary 30 minutes consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat. Thank you, everyone. We hope you have found today's session informative and useful. We hope to see you again at our next talk. Till then, stay safe and have a great day.
Thank you, Diana. Thank you, everyone.